Yeah.
You guys ready?
Yes, sir.
For one person to turn that thing around like you did.
Okay, I think we've got our starting time, so we'll get started if that's okay with everyone. Good afternoon. So we'll call this meeting to order. We'll start off by standing, let's do the Pledge of Allegiance.
Pledge allegiance to the flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
And you may have to pull your mic a little closer to you since we're wearing masks.
Yep.
If you want to maybe just try to talk into it to see if it's working, because I couldn't hear you over the speakers.
Okay, is that better? Still not?
I don't. Can you say test?
This is, unless I kiss it, this is as close as I get.
I don't know that they're working.
Test 1, 2.
Test.
I can find out.
We need to hold off on that then. I need to wait a second. Test, no. Test. Oh, sorry.
No, you're.
Test.
Does one get in here now, please? Should be.
Test.
Okay.
We on now?
Oh, yes.
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 Very good.
Yes.
Yes.
Okay, all right, so let's get started. First off, I want to thank everybody for coming this afternoon. You may notice we've got a few less people here tonight. So we'll go ahead, we'll do a roll call if that's okay, just to make sure everybody knows who everybody is, because I know this is the first time for a couple of you guys, so.
All right, Dale Ludy.
Stephen Overcash.
And I'm Ronald Fight.
And Ron, Mr. Chairman, I have Sam Dedman is virtually here by in a virtual situation, and he's connected to my phone, so if there's any questions, he'll relay them to me, and I will speak on his behalf.
Great, I appreciate him doing that, and I believe that should give us a quorum, it gives us 4.
Yes.
So that should satisfy those requirements. Okay, is there any announcements from the board, anything that y'all would like to bring up before we get started? We've got a pretty busy night tonight. So let's just go ahead. The minutes of the meeting, did both of you guys receive your copies? Any changes, additions to those minutes? Do I have a motion to accept those minutes?
Make a motion to accept the meetings.
And a second? Okay. I'm sure all in favor, so those are accepted as stand. Okay, so we're going to move right into the meat of the matter tonight. So we've got Mr. Rick Flo with us tonight, going over our 160D. So been on the agenda on number 6 item, this is where we're reviewing the draft items. So Rick, without further ado, I'm going to turn the meeting over to you.
Thank you, Mr. Chairman. Can you hear me okay? Am I getting picked up?
Yeah,
Okay. I feel compelled to speak louder with the mask on than I normally do. As you recall from the very early stages, we talked about how we were going to kind of leapfrog these. We introduced a bundle of articles at the last meeting, and everybody read all of them and enjoyed them thoroughly, I'm sure. And so tonight, what I want to do in order to kind of review them efficiently, since we've done the introduction of them, is kind of call them out one by one and see if there are any places we want to stop and discuss anything. Article 1 is your general purpose and authority article. Was there anything that anyone had any questions about or discussion about? I do have some updates for you on that coming up in a little while. You'll see, not on that article, but it ties back to that article. Any questions about any of the language in there, any of the provisions? That's kind of what sets the tone, it sets it up, it repeals the old stuff, it has a few legal provisions in it regarding severability and conflict and interpretations, and creates the map, which is a page of the ordinance, and then deals with that state of emergency at the end. If I'm hearing none, then I'm going to, Mr. Chairman, I'm going to kind of check that off, that draft is just right now our working draft. There's no vote on these on an individual basis. That will come as you conclude the project later in a couple of months or less. When you vote for the plan, vote for the ordinance, and then a consistency statement. So I'm going to check off Article 1 as being reviewed. That doesn't mean we can't make changes. You can bring changes back at any point in time up to the point where you make your vote to recommend to the Board of Aldermen, okay?
And
So-
Rick, I got a text from Sam. He just questioned title, question mark. Is that part of the short title? Is that part of that section?
Landis Development Ordinance, that's correct.
Okay.
That's the first thing it does is it sort of names itself. And then it also legitimizes the use of the acronym LDO.
The highlighted areas that are in that particular page are the ones that will be filled in at the point in time this
That's
is submitted to the town board.
That's correct. That's where we've got to do a little bit of homework. We've got some things, but we still got to dig up, and because we don't want to guess at the current ordinance's information. We want to make sure that we repeal the actual current ordinance in its entirety. So we are setting up a sequence of sort of handoff, like a relay race between the old one and the new one. So we don't have two in effect at one time or anything like that, okay? And so those are yellows to help us remember to circle back and fill those blanks in, at least by the time the governing board votes on it. Because, see, they are going to receive the plan at the same time they probably receive the ordinance, unless y'all break that up and do it at different meetings. So we may not have those dates to fill in until they actually adopt the plan. So I actually have all the originals right here, so I can deal with things on the fly. That way I can provide it to the clerk, because the clerk is the domain of those official records. So that's very good questions. I'm glad you pointed those out. But that's what is kind of our big thing. And you'll notice in my little notebook I have a little tag right here which calls my attention back to pages 1 and 2 before we get too far in. You'll notice that the order of these on the agenda skips over number 2. Article number 2 is actually down in those character elements from the reading guide. And the reason we have that right up front is for people that really, you don't need to really look up what district they're in or any of that stuff, just normal things like a fence or a driveway or, you know, an air conditioning unit or something like that. That's where they could find those standard little answers. So number 2 is going to be picked up as we get further down into the character elements.
Okay.
Article number 3, probably the most exciting content in here is the definitions and symbols and things of that nature. You notice some yellow appearing in the abbreviations where I've got some tentative names for some districts that will be unfolding over the next few meetings and what have you as we get closer and closer to that. But most of these are terms. They're not necessarily just a word. Okay, except in some cases, development. What does development mean? It's really talking about the context of land development, you know, not like improving a process or something like that, but the development of land. Any questions about any of those abbreviations?
I had a couple.
Okay,
In the agricultural use definition, I was
Okay.
just looking for some clarity. Is that specific to a particular amount of square footage or acreage of land that we're discussing here?
no, sir.
Okay.
Your agricultural use is something that, believe it or not, we have to define these things so that when somebody is saying, well, I'm just farming it, I don't have an agricultural use. You know, we have to define these in terms of a number of aspects. Now, bona fide farms, which meet certain criteria, are actually exempt from zoning out in the extraterritorial jurisdiction, but not in the city limits.
Yep.
Okay?
Okay.
Little details like that. Some of these overlap with the flood section in Article 19 as well, and that's where it gets really tied to some federal criteria. Any other questions about Article 3?
Sam question says that there are several missing from the previous version. Are you in a position to, without knowing what they are?
I did have a couple where I had some repetitive ones, where for whatever reason, as I built this thing, I had them in there twice, like if I was taking them out of flood or moving an updated one, and I didn't delete the old one, so I had a few in there that were duplicates. And that's why this was freshened up in December from the original version.
I'm not looking to what I call begin to split and get too specific in this, in the definitions. But for example, like on athletic field, with so many things changing, now we have, golf that is using frisbees and other outdoor activities and so forth. This is sort of a generic statement on what the definition of an athletic field is. And we have a couple of ball fields here in town. And I guess I'm questioning, is this something that we have the latitude to be able to clarify as things go on, or is this something that has to be spelled out now?
No, you can, you do have some latitude in that if you want to. Golf courses are not under that same definition.
Right.
They're referenced differently. They're a use of their own. We use, e.g. softball, soccer, football, so there's a clear example. It's not an exhaustive list by any means. But that's what that's about. If you've got something in particular that you're concerned with, like people have been abusing the permitting of them, which is usually not the case. I've not seen that before, but it's not unlikely. But a lot of these are things that are either an accessory use, like to a school or a church, or a park. Okay.
Okay. Good enough. Good.
Any other comments in Article 3? And remember, if you run across anything, or if anything gives you heartburn, I have a little pack of sticky notes that I use, and I make flags on my pages so I can not lose track of things. Don't hesitate to do that, and then if we need to, we can circle back on that. So this is not over until you vote, make a motion and vote to send it up, which is still at least a couple months away, I would think.
I have a question on car lot definitions.
Okay.
I'm assuming it's not in cars, so it must be an auto.
Well, I don't know that I have a definition in there. That's why when you said that, it kind of surprised me a little bit. Automobile, usually I deal with it as automobile, like on repairs and stuff like that, but I don't have one on there for sales. I don't have a definition of it.
So what would be the effect of not having a definition for automobile sales? Would there be a?
I don't think there would be at all. Not ever had any trouble with, I've had trouble with auto dealership use permits and things of that nature or violations, but not to the point where there was an issue with the definition of it. The state actually defines that too through the licensing, and that's one of the little places where we kind of stay back a little bit. Because the state actually requires us at town hall to sign off. Let's say somebody wanted to open a car lot. One of the things that when the applicant submits that for their dealership license or for a new location on that dealership license, the state will actually send us at town hall a letter requesting zoning clearance, basically making sure that at the location that's stated on their application to the state, that complies with local rules as well. I've signed off on many of those. And I've not signed off on some where they wanted to open up in locations that were not permitted.
Yeah, I think the thing that comes to my mind when I think about this is all the people I've known in my life where they have a family car, they want to sell the family car, they park it on the corner, put a for sale sign on it, and next thing you know, a friend of a friend of a friend has a couple of cars and they want to add to it, and it begins to grow.
That's where we have to use what's called the art of interpretation.
Yeah.
Okay? And, because there are limits set in the statutes. For example, let's say that I got really just going, and I was trading my car in every other month, and I got to the point where I was buying and selling now my 6th car. That's the trigger point. Believe it or not, you can go to 6 before you are classified as an auto dealership.
Okay, that's the magic number I think I was looking for
Now,
when you
if
said
they
that.
are, if you've got someone who is not, and that's if I put it in my name. If
Right.
you've got someone who is turning those vehicles without taking title to them, in other words, they get somebody to sign a title and they don't transfer it, they just put it out there for sale, then they're acting as a dealer outside of the state's licensing law. And when we see that, and we just have, a lot of times, we have to use common sense in zoning administration. We have to look at that, and if it smells like a duck and is walking like a duck, it must be a duck. And if we report that in, or we double check with DMV to find out, do they have a dealership license issued at that location, then we can clean up that issue pretty quickly, because normally they'll say, well, no, we don't. Well, we didn't just tell on them, we just asked a question. And we save ourselves the enforcement action,
Gotcha,
okay?
gotcha.
But those are good questions, Mr. Barefoot. If you like something in there, then we can use the state's definition, okay? But sometimes when you've got a licensing group, we have to stand back a little bit. That's why they did away with business licenses in North Carolina about 5 years ago, 6 years ago.
Yeah, I'm probably going a little bit too specific on some of these examples. I'm just trying to think about down the road, if we had somebody that sort of went down that road and they said, well, you let so-and-so sell all these cars and now you won't let me. And you talked about, I think in last meeting's example of Little Ricky, I remember you used the
Yeah.
example of.
I'm the bad guy.
Yeah, but I guess I'm trying to anticipate those type of things happening.
Yeah, and I see where you're going, and I'm not trying to talk myself out of a little extra labor, but what I want to try to relay to you, and I mentioned the term a few minutes ago, the art of administration. If we tighten everything down, absolutely, you can count on something coming up that we didn't anticipate. And if we have tightened it so far that we have narrowed our ability to use judgment and to make an interpretation.
Yeah.
Because if a citizen is aggrieved, doesn't like, if they're aggrieved by the interpretation that the zoning official makes, they have the right to appeal to the Board of Adjustment. The Board of Adjustment's actually set up for 2 specific reasons in North Carolina. One is variances, which most boards are kind of familiar with. The second is hearing appeals. And what your role becomes, if you're the Board of Adjustment, is to interpret what is the meaning in the ordinance. Did the staff person apply and interpret that consistent with the intent in the ordinance? And so the Board of Adjustment actually makes that final decision. So there is a backup to that. So if you get a complaint, that should raise an awareness. And the staff person, I don't know, if, Mr. Barefoot, if you've seen this before, but I've seen this happen from time to time where a staff person will say, well, you know what, I was looking at it this way, but maybe I'm not the smartest person when it comes to maybe automobile dealerships or whatever the subject is at hand. I'm going to ask my Board of Adjustment. So I, as the staff person, say, I want to put something on the agenda and ask for an interpretation.
Yeah.
What is it? I'm looking at this provision, I'm looking at that provision, and I've got this and I've got that. What is is this a dealership, or is this somebody that's just floating by the edge on the thin ice? If we declare it a dealership, but the state law doesn't, the concern I would have there is that they were probably feeling that they've got a grievance, that there's this double standard out there.
Right.
Okay.
Yep.
So I'm sort of picking apart the edges of what the likely comeback might be, and so I'm going to caution you not to get so tight that we've lost our ability to use judgment because we've got that safety net of the Board of Adjustment to come in and back up staff if need be.
Okay, good,
Okay.
good.
But that's a great example. Car dealerships are a great example. Mobile home parks, I'm going to use an example for you here. Mobile home parks are not defined by the state statutes. There's not a licensing requirement, things of that nature. So do we define those in the ordinance? Absolutely. Hearing any other comments on 3? Hearing none, we'll move on to 4. 4 is affectionately is you. It's the boards themselves. This is what creates them. The statute authorizes local governments to establish these boards, and in fact requires that they establish these 2 boards if you're going to exercise these powers, duties, and authorities in a town. Can you combine them? Yes. I do not recommend that they be combined. I recommend that they be separate boards, but you can appoint the same people to both boards. That keeps the hat wearing a little bit cleaner. I attended virtually through Zoom last night another town where I'm doing the same thing, and it was my first meeting with them, and right before I did my part, they had a variance case. So I got to watch them in action. And I watched them walk right out in the middle of the street with their clothes falling off or something. I mean, it was scary at what they were doing. And they had, and I later on had an opportunity in my part to point out to them the importance of staying in the rules of procedure. They were operating with no rules of procedure, so they were kind of making things up. And if that permit that they issued that last night, that variance that they issued last night were to be challenged, there is no doubt in my mind their authority, their action on that would have been overturned. Absolutely. Clear as could be that it would have been overturned. So this thing about the boards and the planning boards is very serious. It's where the due process part kicks in. Due process is really what the courts care about. They don't mind whether, if you want this area to be commercial and that area to be neighborhoods, and you want the neighborhoods to be like this or be like that, they're kind of neutral on all that stuff. But the rights of property owners, if you step out of bounds in the notification or the exercise of that authority or the proper administration of that authority, things of that nature, they will take you down every time. They'll take you down every time. That due process, it's called, is the most serious part. And due process really lives in 2 arenas. One, the boards, and the other, the staff, to make sure that we're not violating people's rights. They have the right to follow these processes, the right to request a change, to request a rezoning, to apply for permits, to apply for the ability to develop their property, all of those things that are built in. And if we fail in our notification, or we don't properly have the quorum present, or something along those lines, then we have violated the due process. And that is, I can say with quite a degree of confidence, 100% fatal to the action, meaning whatever was done that way is invalid and would be overturned if it was appealed. And so you'll see things in here, and this is not all the rules of procedure. This is creating you and laying out some groundwork. Okay, how you're appointed, the oath of office, et cetera, et cetera. The rules of procedure stand outside the ordinance. They're your own sort of bylaws as to how you want to conduct the meeting. As long as you're within some parameters, that's pretty flexible. And you'll see those 2 sets, and that's what goes back in tab 27. Okay? So that's one area that I want you to become comfortable in, because it respects you as a body politic, if you will. Okay?
Mm-hmm.
It legitimizes you. Any questions about that? This is where I've got some information that I want to share with you. I have replaced this article. No, wait a minute. No, this is correct. This is correct. This does not have, you do not have extraterritorial jurisdiction, and this one does not have. This is the one where sometimes there'll be some membership appointment stuff. I want to make sure I have the right one in here. And this is correct for you. I don't have a change on this. I apologize. That's my confusion. But you'll notice we've set it up at 7. That's what we were instructed, at 7 members early on. That's a lot for a small town to keep appointed, just for the alderman to keep that in mind, because it's a lot of volunteers you need to track down. It is actually a fairly good number if you're gonna make the planning board also the Board of Adjustment in one regard, and that regard is that now you've got enough people to where your Board of Adjustment can have a 5-member board with two alternates. And when you're gonna use the same group of people, I recommend that you do have alternates, that those alternates come to the meetings, they don't stay away, they don't, not just in case, they're there in case they need to be seated. Like if there's a conflict of interest, somebody says, oh my gosh, that's my next door neighbor, I need to excuse myself, there's someone that's heard all the evidence that can step right in. So 7 is good if they're gonna be the same people, and that's why I'm looking at the alderman in the room.
Sure.
It's not necessary if you're gonna use different people for the different roles. The reason that I like using the same people is if your ordinance is fairly smooth operating, and I'm pretty confident this is pretty smooth, you shouldn't have a variance unless we mess up applying zoning to the ground. You shouldn't have maybe a variance every couple of years. You shouldn't have an appeal, but maybe every 2, 3, 4, 5 years in a town this small, realistically. And trying to have a board set up that stays prepared, that's ready to go, that might not even have to do anything for a couple of years at a time is not very effective. So that's why I recommend keep the same group, let them have that other hat. Double their pay.
That's right.
Let them have that other hat, and that way you tend to have you tend to be able to handle things better, because the Board of Adjustment is the board that has to act kind of court-like. That's judicial that I've mentioned before. That's court-like, where there's testimony. It's not just somebody's opinion. It's testimony. It's evidence-based in a Board of Adjustment. That's why you really don't want to have more than one of those every few years.
Right.
But if you're not ready and you don't get it right, the town's going to lose. And under the new statute, if somebody is aggrieved by the town, it's automatic cost.
Yeah.
Meaning if they've had to hire experts or attorneys or anything, it's automatic. You don't have to go and request the judge to award damages and, cost. The costs are automatic. So it's important that you be tuned in and capable, and we will work with you on that, okay? So don't worry about that. That's one of the things that we like to make sure you're prepped. And I like to suggest a mock hearing. So after you've recommended all your stuff and it goes up to the alderman, the ideal scenario would be able to, at least once a year, have a little Board of Adjustment exercise meeting so that you stay tuned in. So when you are needed, you're there. You're right on. Everything goes smooth. Because there's nothing to be afraid of. But if you're not sure how to handle it, you can actually violate somebody's rights by saying, well, I just asked the engineer a question. Well, if it's evidentiary, that's ex parte communication. You can't do that. That's why we want to train you on that.
Yeah.
Okay? And we'll do that.
Good.
So that's what it is about boards. I've got some yellow in there too, in my notes about members, making sure that we've kind of got our member stuff down pat. So I'm kind of looking at the electeds and the town manager to give me any, frown at me or throw something at me if you feel like I'm getting out of bounds with setting these numbers at 7 and 5, which is really 7 and 7 because you got 2 alternates on the second board. So it's 7 and 5 plus 2. Any other questions about Article 4? All right. Article number 5, and notice how thin that is. It's nice and, short. Article number 5 is amendments. Amendments also is what you're actually doing when you adopt the new ordinance. You're actually, when you vote on this whole thing, you're actually amending by enacting this whole new one and repealing that old one. So they follow the same process, whether you're adopting it brand new or whether you are going in and saying, hey, we found something we want to change. After we've used this for a year or two, we want to add this or change that, because of this thing we got going on around here, whatever it might be. And that amendment process is basically laid out in the statutes. There's one thing that I do that's not required, but it's allowed by the statute, and that is to have on certain actions to have neighborhood meeting. On a rezoning, if you look at page 2, where it says amendment process, whenever it's a zoning map amendment, in parentheses rezoning, if you're looking at the top of page 2, item B, neighborhood meeting, it is required that an applicant for a zoning map amendment, that's a rezoning, that's where you're amending or changing, making a change to that one page of the ordinance, that is the map that applies those districts to the ground. Somebody says, hey, I want to rezone this residential house down on the corner of, Highway 29 to commercial. You go through a map amendment process or a rezoning amendment process. And one of the things that I like to put in there is a neighborhood meeting, so that early on the developer marches over there and notifies everybody that has property around them that they're going to have a little powwow. They're going to have it at the Stag and Doe, or they're going to have it here in Town Hall and make arrangements. But they're going to present their project to the neighbors, okay, before it comes up here to you.
Right.
And everybody comes in this room, and then they're mad at the developer because they think the developer's trying to pull one on them and all that stuff. Because you really need to stay out of the promises that they're going to be standing up there making. You need to make the decision based on what your big picture view is. Are we going with more commercial down there, or we're going to hold back? Which way are we going with it? What's our big picture view? It's not what these 3 people or 12 or 250 people thought about it. That's the governing board's prerogative. Your prerogative is that vision. What is the vision in this area? What is the logical thing in this area to do? And then the governing board takes your recommendation and then holds a legislative hearing for the crowd. And then they can come in and say, well, he told us in that neighborhood meeting he was going to put up cute little puppies and kittens in front of every house, and I haven't seen any evidence of that. Y'all got to make him do that. So, well, we're not going to do that. We'd have to make the decision based on what we think is best for the town. So we're going to weigh your concerns that you don't trust him, and we're going to weigh the planning board's recommendation. We're going to make a decision. Because guess what? If that change occurs and the governing board makes that amendment for that, changing it to commercial or changing it to this kind of place or that kind of place, the next day, if that applicant changes their mind, they have all the rights and privileges of that new district. So they could say, well, I'm planning on opening a great restaurant, Italian cuisine, and that's why I want to rezone this old house and make it a really cool dining experience. And so I need your Highway 29 zoning. And then day after the board votes on it, they decide, no, we're going to tear it down, put up a car lot. If that's in that district, they can do that. You can't hold them to that one thing unless it's like a conditional use, which is even more limited now than it used to be. Okay, conditional zoning, there's no such thing as conditional uses anymore, as of last June. Okay. So it's a very, very detailed process, and this keeps you, just follow it. This keeps you in between the rails, in between the ditches. Okay?
I have one question.
Sure.
It's more, Mr. Barefoot, this is probably a question I think probably might be something you can help me with, because this term planning, zoning, and subdivision administrator shows up numerous times in this book. And I'm not really sure, is that a position we have currently? Is that being filled by somebody now?
We contract that with In Focus. We actually have two
Okay,
ladies.
so that's handled
part-time.
by them. Okay,
There may become a time, and it may come sooner than later, depending upon development activity and some other issues, that we would hire a full-time person, but right now, we have to have one designated. to be
Okay.
the zoning administrator.
I just, in my mind, I'm just trying to clarify who that person physically is, and I think it's maybe the words that were used to describe the job title that maybe threw me for a little bit of a curve.
Well, right, that's what I like to call them, because it covers all those bases.
Yeah.
In a small town, you wear a lot of hats.
Sure.
You know, if you were in a big city, you got a zoning administrator, and you got a planning director, and you got a subdivision administrator, you got all those different players, but in a small town, you don't. I'm glad, Mr. Chairman, you brought that up, because we're gonna be getting to Article 23 ultimately with our introduction in a little while, but I wanna point out to you, that's where that position is actually created. Not budgetarily created.
Right.
But is created as a role which can be filled any number of ways by the town.
Right.
Okay, as Mr. Barefoot was pointing out. But what it does point out is how important it is for that person to be qualified. That's one of the biggest mistakes I see small towns do, is putting persons that, I can't tell you, I've had people that say, well, I'm gonna, do this or do that because, well, they worked over here for this real estate place, and maybe they can do it. You really need to make sure that they're qualified, because they're making interpretations of law all the time.
Yep.
That's one of their key responsibilities, is to interpret this. Okay, and that's created in Article 23. Which is not the least important thing, but it's just in the back because it's administration. It's the thing nobody's going to hardly read. It just has to do its job. It has to make that person. Okay? Any other questions on page 2, you'll notice I've got a time. I set up a time in yellow
Yeah.
for applications for amendments.
Mm-hmm.
For the 15th of any calendar month, that means it would set it up to be ahead of your meeting the next month. That gives about 3.5, sometimes 4 weeks in there because of all the processing that people need to do. So it can make it to your agenda. You have to have a cutoff. You really need to have a cutoff point.
Right.
Okay?
Yep.
Especially if they're trying to time it with a public legislative hearing for the alderman, when's your meeting in the month?
Now the second Monday of the month.
Okay. And you're second Tuesday.
Mm-hmm.
So for all practical purposes, you're almost always a full month apart, but sometimes a little less than a full month apart. So you need that, because you have this 10 to 25 day rule on notifications.
Right.
So this is about right. Otherwise you'd have if you narrowed the gap down on the planning board, they'd have almost no time to get everything right in order to notice for you. So what would happen is it'd be probably a bigger delay between the planning board and the governing board. So I think this works out fairly well. It gives about 3-4 weeks at the high end, almost 4 weeks at the high end, between receiving an application and it being on your docket with all the information and details, and then as much as 4 weeks before it gets to you. So it's a 2-month process to do a rezoning, is what that means. And that's about what it really should be. Unlike the city of Charlotte, where it's about a 6-month process. Any other questions about Article 5 amendments? Before we turn to 6, I do want to take you into another little arena. We've been talking about kind of that amendments as a rezoning or there's a change we want to make in our ordinance. That's the 2 general kind of amendments that you're most familiar with. But if you'll flip over to page 8, there's a tool in the toolbox. Because you've lost the ability to do special use districts and conditional use districts and conditional use permits, you now have 2 tools left in that toolbox under that ballpark. One's called conditional zoning, The other one's called a special use permit, which we'll talk about later. Conditional zoning is not a quasi-judicial process. It is a legislative process, which means it doesn't rely on testimony, it doesn't rely on sworn evidence and all this stuff. But it is still a zoning map amendment. But it's a tool in the toolbox that will let you create, if they apply for it, a kind of a customized zoning district. Okay? So that tool is there. It's, now that we've narrowed in on just that as the only kind of district we can create, there may be some towns that don't have much experience because they always use the old conditional use districts and special use districts, which required you to do both quasi-judicial and legislative processes almost simultaneously. This scales this back and simplifies it to where it's just legislative, which means you make a recommendation to the governing board. Governing board holds a legislative hearing and then they can decide yes or no. Okay? And those conditions, though, this is critical, and I'm so glad we have an alderman here. This is critical. Those conditions have to be in writing if they're added. If it's anything, somebody comes up in the meeting, they say, well, you know, I'm concerned about this. I think we need to modify something, whatever it is. And the developer says, well, I'll be more than happy to do that. That needs to be written into that action, not just in the minutes, but it needs to be on their, it needs to be added to their drawing. It needs to be added to their permit application. It needs to be added to something so that that applicant can then sign it.
Yeah.
That's a requirement.
So it is a condition of approval.
It is. That's
Isn't
right.
that the same as a conditional zoning?
That is conditional zoning, but they can add a condition in the conditional zoning meeting as long as it's done in writing.
You have to have a traceable document.
You gotta have a traceable document, because you might sit down and have it one that's fairly straightforward, where they say, well, we wanna do this, and here's our application, and everybody's happy with the way the application is to add this and delete that. But then in the meeting, if something comes up, you just wanna make sure that gets added to that document, or gets added to that drawing, and that applicant signs it, because that's a statutory requirement, that they agree to it in writing.
Yeah.
And an
Okay.
agreement requires an offer and an acceptance.
Would that be the case for if it was a rezoning to a restaurant and the applicant said that he would make a condition that it would only be a restaurant?
If that's what you want to tie it down, they just need to make sure that they build that in right up front. That's why I separated out the use by right rezoning, straight up rezoning, from this conditional. So if they want, and this is where this conditional stuff actually came from. It came from places where somebody's got an old house, they wanted to convert it, but they were looking at the zoning ordinance, and they had this commercial district and this residential district, and they converted it to commercial, and then next thing you know, the house is torn down, there's a car wash going in, nothing against car washes, but then everybody's upset. So that's where conditional use zoning, the original versions, came from. Steve Davenport and Phil Green. Steve Davenport actually worked for me from 1990 until he passed away in 2017, the inventor of this stuff. But it was a little bit too confusing, so it got boiled down a little bit. And Bill Dustin actually was heavily involved in the conditional zoning modifications to kind of simplify it. Bill also worked with me for a number of years after he left the Central Line Council of Governments, until he retired to Michigan. He's up on the Upper Peninsula right now, by the way. If you can imagine that. He's one of the few year-rounders up in that area. So conditional zoning becomes the tool that can, as Mr. Barefoot pointed out, that can let you tie something down, but it's got to start out that way. You can't get in the middle of a regular rezoning and then suddenly convert it right there on the spot, because you didn't put that public notice out that way. Okay? So that requires some consultation up front, and that's where the zoning staff person comes in to say, okay, I can kind of see between the lines here, read the tea leaves, and I see that this is going to be a hot potato. Would you consider a conditional zoning on that so we can narrow down you know, and they may come back and say, well, you know, what the condition we'll make is that we're gonna retain the structure that's there indefinitely. You gotta be careful with that language. Next thing you know, oops, somebody burned it down last night, you know. So you gotta be super careful with the language in conditional zoning. Okay, you gotta make sure it's got some ties to it, and it limits, the best way to do it is to limit the uses. Say, okay, in this conditional district, we're gonna have a condition, a C-29, we'll call it that, C-29 for Highway 29 area, with a CD, conditional district, and it's gonna eliminate all the listed uses in the use table except restaurant or offices or something that you're comfortable with. Okay? So you've got that tool in the toolbox. You got that tool in the toolbox. And there's parameters in there, you'll see that gets into deviations, so that somebody doesn't use conditional zoning just as a tool to get around all the standards. That's why you'll see these things in there about parking and stuff like that they can only reduce it by a certain percentage. They can't just say, well, we want to do CZ so we don't have to, a conditional zoning district, so we don't have to do any of the other stuff. Be careful of that.
Yeah, I saw your highlighted part in here, and I was getting ready to ask you if there was something specific.
Yeah, that's where we got some numbers we can play with.
Yeah.
Do you want to give them more leeway in the conditional zoning process or less? That's why those highlights are like that. And I have my little flag, so before this project is over, we'll go settle in and we'll talk about that page 9 highlighting to make sure that we are comfortable with it. Any other questions about amendments, now that we've been through both pieces of that? That's Article 5. The review of Article 5. Hearing none, we'll move on to Article 6. Article 6 is that predominantly the role of the Board of Adjustment. So pretend for a moment that you're not planning board members, but that you're Board of Adjustment members. This is basically your world right here in these little half dozen pages. You've got a couple of roles. The first one you'll see on the first page is variances. I don't know how much experience everybody has, so I'm going to be pretty basic in this, but a variance is where you bend a rule because of a hardship. Okay? Where you are going to bend a rule because of a hardship. The hardship cannot be financial. All that stuff's spelled out in there. It's not, can't be because, oh, it's going to cost too much if I do it this way. That's not an option. That's state law. It's not me being difficult. Or it's in the statute. I'm not an attorney, so I can't give you legal advice, but that's in the statute. And so let's say, for example, that I've got a lot down at the dip on the road, where the road dips down right before it crosses the creek, and at my place where I live right there at my house, my driveway comes in over here because of the way the hill is and the way the curve in the road is, and to stay away from the bridge. I couldn't get my driveway down too close to the bridge, so I had to move it up here. And so I got the house down a little bit, but we want to add a room on that house. But when I go to do that, it says that I got to stay a certain distance off the property line. Well, the property line is the creek on my plat, and it used to be over there, and now it's over here because it's washed out every year. Ever since they built that facility up the creek up there, it's gotten worse, and it's all. See what I mean? They're going to start clouding it up with all this stuff. The point is, it's outside of their control. And the zoning taken literally might be saying you got to be 10 feet off that property line to put up to do that addition on the house or something like that, and they can't meet that. Not that you'd really want to be closer to the creek, but they can't meet that for some reason or another that's outside of their control. This is the leeway that the Board of Adjustment can grant to allow them to reduce that to 6 or something like that. Okay, that's what a variance is about. The second, and there's all the process in there for that. Okay, and the notifications and all these things that staff has to do to set you up for success in you being able to conduct a fair hearing. It's an evidentiary process, which means they have to show evidence of these hardships, of these conditions. It's sworn. They swear or affirm their testimony. If a professional's involved, that person has to demonstrate that they are an expert in the field. I'm an expert in hydrology or civil engineering or construction or whatever the case may be. And the standards of review appear right in the middle of page 3. That's the part that the Board of Adjustment's decision is based on. That's why you'll see some italics right there to kind of get your attention. The Board of Adjustment's decision shall be based on competent material and substantial evidence in the record. And you have to make these findings. You have to basically check all 4 of these off in the motion. Or there can be a separate motion for each one. But the point is that has to go into the record, Madam Clerk. Those findings do. And that's been generally the same law and generally unchanged for the past 60 years in North Carolina. But it's a little more serious now. The biggest thing that they're gonna notice is it's no longer a public hearing on that evidence, on that variance. The things that have been added are that the name is called an evidentiary hearing, and that the only people that can participate in that hearing are people with standing. So the chair, if somebody comes up just because they hate the guy that's applied for the variance, used to be married, wants to come up here and tell you what a scoundrel Rick is, you know, and that y'all shouldn't give it to him because he's behind on his payments on the house or whatever. You know, or he's crazy, whatever they want to say, and they can say all kinds of stuff, okay? But you have to base it on the facts that they can demonstrate. Well, standing eliminates those folks who might have an emotional attachment, and it limits it to the property owner and those adjacent property owners. And unless somebody can show that they are affected by it, okay? Maybe they're right downstream and somebody wants to be able to pave everything instead of just the limits in the ordinance because they need to be able to turn the truck around or something. You know, they have to be able to show that they have, that they're going to be harmed by it. Somebody lives downstream would say, well, I might be harmed by this, so I want to be recognized as having standing. So those are some little changes that actually came out of court cases that were not in our statutes for years, but they were in some older court cases, but nobody knew about it because nobody runs around and checks all the court cases before they hold a hearing. So now that's been codified into the statute. That means written into the law. The second aspect is those appeals. I mentioned those earlier, when we were talking about the administrator. That's that process right there. There's also standing in that as well. Now, appeals quite often triggered when somebody sees something they don't like. And this is going to bring another new piece that I'm quite familiar with the origins of how this got into the statute. It involved me. And I made sure it got into the statute with a friend of mine who was in the state senate at the time. The notion was in the case law for years. It's called constructive notice, and it's at the top of page 5. Constructive notice works something like this. Under the ordinances of the past, if Shelley in the planning department issued a zoning permit to build a house, and that person can keep that permit on the shelf for a year. So they go home and they wait for 3 or 4 months, and then they pull it out and go get the building permit and start the house. And I lived next door and didn't know about it, but the ordinance used to say that I could appeal only within 30 days of the issuance of that permit, but there was no way for me to constructively notice that the permit had been issued. So constructive notice was added to the statute. That means if that person holding that permit wants that clock to start running because they know it's going to be problem in the neighborhood, then they have to go out and put up a sign that says, notice, zoning decision, and the information's contained right there. It even goes into the size of the letters.
Yeah.
Okay? That means that the public has been put on notice that some decision has been made, and that decision can be appealed. And if you want the clock to run, the constructive notice clicks in. Otherwise, it doesn't start running until somebody goes out there and digs the footings. And then you go, oh my goodness, that's too close, or that's not right. Okay? Yeah, there was a case once about that. The Board of Adjustment will also be involved in special use permits, but that's not spelled out in this. That's spelled out in where we're going in a few minutes. But so the Board of Adjustment, the way I've got it drafted, is going to have a third function. And that's another reason why I like planning board members to wear both of those hats, because that way your planning board members are already kind of tuned in to the whole arena around standards and specifications. You don't have to memorize them or know about them as much as you know kind of how this works. Town councils, in many cases in the past, sometimes would try to serve as the planning boards or Board of Adjustments. And the statutes are really steering away from the elected officials, trying to wear an elected official hat and an advisory or an appellate body hat. So you're sticking to your legislative world. Could you do the special use permits? Yes. The Board of Adjustment doesn't have to be the body to do it, but I recommend from my experience that you stay out of that dangerous territory, because it's very difficult for sometimes people that are politically inclined. This is not a criticism, it's just a fact, that for elected folks to not be able to completely set that aside and act as a quasi-judicial body. They can do it if they're really well disciplined. But if they start going, well, I want to do this, I want to see that, because people feel that they should have access to their elected officials. And one of the things that's most common as a problem in quasi-judicial is called ex parte communication. That's where one of the parties to that appeal or that variance or that special use permit picks up the phone and wants to talk to you about it. And if you're an elected official in that role, that citizen might be more apt to do that than they would maybe planning board members who are not as high a profile, or Board of Adjustment members that are not as high a profile in the community. So it's really intended to kind of protect you guys, not to say that you can't do the job, but to say that I've seen more problems with it than I have successes with it. If you trust the people you appoint to these boards to do the job properly, then go for it. If you don't, then take that authority over, but watch out for making sure you keep those hats straight, because that's easy to appeal, and if it goes south on you, it's automatic cost. Okay. So that's the reason that it's written the way that it is. So I've kind of backed into the next one, which is Article 7, even though I've jumped ahead by bringing up the point about special use approvals, which is actually about halfway through Article 7. Article 7 is really about all of the different approval processes that reside out there. Instead of having them in broken up all over your ordinance, they're all kind of in one convenient place. So a zoning permit, special event permit, site plan, special uses, uses with additional standards, sign permits, subdivisions, floodplain permits. Those last three are a different arena. Zoning vested rights, I'm gonna go ahead and tell you right now, I'm gonna sort of want to jump to that. A vested right means that I got this permit the other day, and I have the right to use it. I have the right to develop in accordance with what I have obtained. It's an entitlement on my property. It belongs to my property. If I went and sold that property today, that right goes with it. And the new owner has that right to develop or what have you. So when an approval is granted, there is an inherent right to exercise that, okay, that has to be protected. In the past, there was a separate procedure for trying to extend that period of time to say, well, this is kind of a big project. I'm putting it together for a big developer out of California. I need more time. And there was a process where you could then come back to the boards and have a public hearing and do all that just to get an extension of time. And that's nuts. So what I've done is taken the vested rights process, which is short and long, depending on the size of the project, and I've actually built it into each permit type. So if you're looking at a big subdivision, or a big subdivision with multiple phases, whether it's a 5-year or a 7-year, and I've set it up where there's a certain amount of time that's granted as soon as the project's approved, and then one extension can be granted. And you'll see that when you look at something like subdivisions or site plan. Okay, you might say, well, gosh, yeah, it shows in here that it's valid for 2 years, and there can be an extension for up to 3 additional years for a total of 5, based on justification that's submitted and things like that. So I built that into each one and not kept it as a separate item, which your old ordinance has it as a separate little world, which creates a lot of problems because nobody ever does it. And then they gripe when their permits start expiring after a year or 2 years, because that's generally a zoning permit's good for a year, and generally a subdivision preliminary plat's good for 2 years. That's just not enough time on large-scale projects. So we've built that in. Notices and hearings, that's pretty clear. It's in the back. It talks about that. And then development agreements. I want to sort of jump ahead to those big tools in the toolbox. Development agreements are a wonderful tool. A development agreement can help address a lot of different nuances that might come up in a big project. Let's suppose that I'm the developer and I say, okay, I'm doing this big subdivision. It's going to be wonderful, beautiful, nicest place in town, yada, yada, yada. And you know, I'd love for the town to work with me on that. We're going to bring so much tax base, and love for y'all to work with me on running that water line out there and sharing that cost or whatever the case may be. What a development agreement does is it gives you a place to park all that detail. Okay? All right, developer, you know, that's a good idea. We need to run water out there because we got another target we're trying to hit over there. You guys are going to pay for the normal capacity that you would have, but we're going to pay the difference on an upsizing, and we build that into that development agreement. Developers understand agreements a lot better than they do a zoning approval. You follow me? So it gives you a tool in the toolbox to sort of work in their arena. You know, you have to approve a development agreement, and it's spelled out starting on page 25. You have to approve a development agreement with an ordinance and a hearing and everything to do that, but that is one of the most advanced tools that we've gotten in years and years and years. It also lets the developer lock their zoning in. So maybe a future election, a future something can't just unravel it. Because if they're making millions of dollars in investments and then somebody wants to, you know, pick at them, it kind of protects them. So this works 2 ways. It's not just about protecting the town, it's about protecting those that invest in your town in a good faith manner if you follow the tools in the toolbox. Everything up above that, subdivision plats, sign permits, site plans, that's all pretty straightforward stuff. And I'm sure that you've looked at it, and so if anybody's got any questions, I just wanted to kind of go into a little bit of depth on those while they're there. Does anybody have any questions about anything they saw in Article 7 that they want to zero in on? We try to explain it all in that first couple of pages, like who does it and all that sort of thing, because you got certain things that the county might do, like a building permit, that the town doesn't actually do, but it points people in the right direction.
On my Article 7, I don't have anything in it. The only thing I've got is 3 pages.
What page numbers are there at the bottom?
Oh, it's on the other side, okay.
Is it in the wrong tab?
I was on tab 7, but,
Should be right behind tab 7, should be your Article 7.
okay. So I just go with that one you have there.
You have this.
Article
You,
6.
you should have about,
27 or 28 pages.
yeah, it's pretty hefty. And then there's also some certificates. You might be looking, when you say 3 pages,
They had it mixed with 6.
you got the certificates.
Yeah, I've got the
The
certificate.
certificates sit at the back of Article 7.
Right.
If I'm a surveyor, I'm
That's
Mel
what it is.
Thompson Associates, a surveyor up the
Mixed with
street.
6.
I can then just download this off the town's website and paste them right on my drawings. And I've got exactly what needs to be on there. So we create those and make them handy. 1 page for all subdivisions, and then a couple of pages worth of stuff for big deal things, where there's lots of stuff going on, new streets and everything. So you hadn't had a chance to look at that, then, I'll take it.
No.
Feel free, nobody's voting on anything right now, okay? Feel free to take your time through that. The certificate should be at the back of it. This goes into what's on a site plan drawing, it goes into all that kind of stuff. When somebody's, if you got an engineer looking it up, so they can submit their plans to you, this tells them what all they gotta have on the sketch plan and what all they'd have to have on the development plan. Tells them how long it's good for. In fact, on page 13,
Yeah, so this will come out. So this, yeah.
on page 13, something I want to point out that the new statutes do for us, that's towards the end of,
I don't know, he's asking a good question, just want to clarify.
Okay.
And this is actually on the title page for Article 7.
the last page.
Actually, it's the first page.
Oh, the first page?
Yeah. And I think probably what happened is, Article 7.4, certificates issued, and it says by Gaston County.
Oh, that's because we needed,
That's what
we
you built
we
off
didn't have enough people in Rowan County. No, that would be a typo on my part.
Well, I think the new one, and this is replacement.
Oh, I might,
pages.
yeah, I probably gave you some early drafts that
Yeah.
were, so
You
that we
did.
could start getting them into
Yeah.
your head.
I
No,
think you
it's-
mentioned last meeting, that
Because-
was just a typographical.
Does this need to be county specific? Does this one need to say Rowan County?
No, I actually took out the county reference. I don't know, it was in the, you're just talking about the table of contents, not
Yeah,
the,
yeah.
not page 1.
Yeah,
The
right,
table
right.
of contents, right. Normally, I didn't, that's the only place it appeared, that an actual name appeared in there, and I decided to just not even do that in table of contents. Because I don't want to have to spend time fixing a table of contents. Okay. Does that answer your concern? Okay. All right, let's take a look at page 13 in Article 7 for just a second. This is back in the details of a special use permit, which is one of those things the Board of Adjustment is going to be handling. But this is one of the big things that the new statutes do that is huge. If you look at permit validity at the bottom of that page, where I built in the vested rights, that is that multi-phase development, the last sentence can go up all the way up to 7 years and all that stuff, that's within the state statute, but that's the cutoff point, okay? That means you might be working under a special use permit for several years if you're a developer. Now, during that 7 years, from the time that evidentiary hearing with those site plans was handled, way back in 2022 or something like that, and here we are in 2030, something has changed along the way. I got this problem, the market's changed, we've had a recession, whatever, but I want to make a little modification, okay? Let's suppose that something has changed during that 7-year window. We'll turn the page, and you'll see right in the middle of the page, minor modifications. In the past, that did not exist at all. It was out of bounds. if I had a project and I needed to change something under a special use permit, I had to come back to the town and apply again and go through a process of amending my approval. Maybe I needed to just move a lot line a couple feet. Maybe, all kinds of things that could have come up. The state statute said, you know what? Let's give folks, from a common sense standpoint, the ability to make minor modifications. So in here, we spell out the parameters that would allow your staff to look at that change that they need to make, and if it fits inside these parameters, they could just sign off on it and be done and not have to come back, go through a hearing, do all that again to make a change. Let's say they needed to move a line a foot or something. There's a provision for it, okay? We're going to talk about that topic again in a little while, about modifications, but this is how it applies inside of a quasi-judicial process. Now, that may not excite you guys, but it's really exciting stuff for somebody like me that for decades, that's been a rigid wall that we couldn't mess with. And now we've actually got the ability to establish criteria. Now, you don't have to give that flexibility to your staff if you don't want to. But this is what it would look like if you did. You're authorized to grant a little bit of leeway. That's why those numbers are in there, so we got to say something. If you want to say, well, we don't want to give them 10%, we want to give them 4% leeway, or 2% leeway, or no more than 5 inches leeway, we can say that. We just have to say something. They can't have just a blank, well, I'm the staff person, I got all this power, I can just say yes or no. No, we have to define the limits of that modification, okay?
Just a quick comment and
Sure.
or question on, as it relates to 1 and 2, because I think this did come up in either conversation of where you were driving these sessions to go.
Right.
That, for example, that 10% or 24 inches, whichever is greater. Likewise, in number 2, the reduction of up to 25%. Where did those percentages come from? Precedents from?
Some experience.
Okay.
Yeah, and I've used that over and over and over and over again. I've had some places tighten it down a little bit. I haven't had anybody loosen it up anymore.
Okay.
When you are working in a smaller community, and that's predominantly where I work,
Mm-hmm.
a project might be smaller, and so it's about how much heartburn does the community really want. If you see a better number, by all means, it's your prerogative. I would not loosen it more than that. Okay, because then you're starting to really kind of defeat the purpose. The whole idea here is they got out in the field and maybe they needed to adjust the angle on the line just a little bit, or somebody set this house up and the way they pointed their brick, they set their framing and they set their foundation and they ended up being a few inches short. You're gonna make them tear the house down or go back through all the process again.
All right.
Let's find a way to have a little bit of push and pull. I wouldn't give them, a huge amount of leeway. Parking, and that's why that's in yellow, is that percentage. When you're looking at those districts, those are the districts where you're gonna have the most creative solutions. Your downtown area and your mixed-use districts. That's where you're creating maybe a second downtown, type of thing. Mixed-use district might be, anybody ever been to Burkdale? That's a mixed-use district. That's a big one.
Yeah.
It's a giant example, but just kind of calls you out. That's where you got a lot going on. And that's one of the parking aspect is 25%. Because a lot of times when you get in your mixed use and your main street, there's a whole lot of sharing. I'm going to park here and I'm going to go in here and eat, and then my wife and I are going to walk next door and buy something, but we're not going to move the car.
Right.
So do we make them develop all of those, each individual store have all the parking spaces? When in fact, we might be in certain situations where we can just leave the car and go to both stores, or go to two different places. So that's why that percentage is high, but it's also tied to certain districts and some criteria there.
Correct.
It's not across the board leeway. This is a good time to point out, because we've talked a little bit about special uses. Special uses in your ordinance are gonna have a long list. It's actually Article 10, which we're nowhere close to yet. We're gonna have a lot of the conditions that go with those special uses already listed, based on experience. An example of a special use might be self-service car wash. You know, you'll see those go with a convenience store a lot of times. A lot of times they push them to the back. A lot of times they're open all night long, but you got cars going all the way to the back of the property and panning their lights, and there might be a neighborhood behind it. So we might have additional screening requirement. Maybe they have to add a opaque fence right there in that area rather than just some plants. You follow me? If they didn't have the car wash, maybe the plants would be enough. So we've got a pretty good list of about 35 uses with some additional standards. They can do them. They don't have to come to the board and ask for it. They just have a few extra things to meet, and the use table points them to the exact standard that they have to meet. But that's what a use with additional standards is. So special uses are the really weird stuff. The uses with additional standards are things that are pretty normal, but might have a few things that people would be concerned about, and how do we address those? And then there's normal listed uses. That's just like, well, you know, restaurants are listed in the highway commercial, they're listed in the downtown. You just follow the normal standards in here. You don't need any, you know, act of Congress, so to speak. We don't need to get all the boards together to decide if we're gonna let them have a restaurant where the restaurant used to be. You know what I mean? So a lot of your listed uses are those things that are really about the general character of those districts. The ones with additional standards are the ones with a little bit more sensitivity. The ones that are special uses are the ones that are usually scary. An example of a special use permit might be a asphalt plant, where people get really concerned about odor. You know, I'm 2 miles away, but I'm still gonna tell it's over there, you know. And the special uses can get a little bit detailed and what have you. And you'll see a lot of really detailed criteria in Article 10 on special uses. The first ones will be basic, the second group will be really detailed, okay? And that's all speaking from experience. No need to reinvent the wheel on a lot of that stuff. Accessory dwellings, kind of a hot topic right now, is one of those uses with additional standards. You know, you might want it to kind of sort of match the house if they're gonna do something detached or freestanding, to put their father-in-law or mother-in-law in. So that's an example, okay? So that's what Article 7 is all about. It's all about all those permit processes for all the different avenues that you can follow for that. One of the things I want to point out, and I mentioned this very early in my meetings with you, that the statutes have really gotten clear that planning boards is to try to keep planning boards from making stuff up when it comes to approvals. Best way to do that is to have the projects come to you for not a vote, but input. So staff lays it all out, here's all the plans, and you've all got comments, and staff takes those comments and sits down with the developer and tries to address those comments, rather than you taking a vote, because the statutes say that you can't require anything that the ordinance doesn't automatically require already. So when a board starts getting, you know, a little aggressive and asking for all kinds of stuff, they're actually out of bounds. if they're in a conventional subdivision plat review approval process. You follow me?
Yep.
So we've tried to make sure that we're not setting up places for any litigious sideshows. Okay, we really want the boards to be able to do their part and to stay in bounds and to stay out of trouble. So that's a big change for you. You've probably, in the past, the planning board's probably voted on like a new subdivision. Well, that was actually in case law. It just wasn't in the statute. There was a list in the statute, but it was kind of a general list. That's gotten a little tighter. And the instructions are a little clearer now, that you have to be careful. You can't just throw stuff out there. If it's on a conditional process and they agree, yeah. If it's on a special use permit and you're the Board of Adjustment and they agree, yeah. But if it's somebody comes in with a plat and y'all start talking and start saying, well, I'm not gonna vote for it unless you do this, way out of bounds, way out of bounds, okay? So this makes sure that staff is keeping it to the specs in the ordinance. So you get to do more of the fun stuff and let the staff do the heavy lifting, okay? But I wanted to point that out to you, that that's in Article 7. So that's the article as well as the certifications or certificates that go with Article 7. I told you a little while ago that we were going to talk a little bit about modifications again. Article 14 is where we host the modifications that staff can make to general permits. I don't have it hidden away in Article 7. I have it right out there in the midst of all the stuff that the engineers and architects are going to be working in. Article 14 makes it easy for them to find. So if I'm an engineer and I'm working on a site plan for the new, restaurant over here next to so-and-so's place or Stag and Doe or something like that, and I want to, and I've got a problem, I'm running into a problem. The site's not working, something's not working here. I can see right there on my screen when I'm looking at all the other articles that I'm using, like parking and landscaping and all that stuff, because that's what I'm going to be doing when I finally figure out that there's a challenge on the site, and I'm going to see right there flexible development standards, and I'm going to look, and I'm going to call, and I'm going to talk to somebody at City Hall, and I'm going to find out, oh, great, it's not a big deal, I can get 3 inches, or whatever I needed there. There's a way to do that, but it has to be justified. They have to show why they need that modification. So modification is a staff level version of what a Board of Adjustment would do with a variance. But a Board of Adjustment can vary a lot further than staff can modify. Does that make sense? So this is over in the normal permit world, not that special use permit world. But it's a new tool that the state has given us under both categories, by right permits and special use evidentiary based permits. It's only a couple of pages long, and it spells out that criteria for them. So you look at that, and you'll see that there's some consistency there. They're almost the same amount of leeway, whether it's a special use permit or not a special use permit. And I don't see a reason to deviate that between the two types of permits, that one needs more flexibility than the other. But you might. And I'll be open to whatever suggestions you've got there, okay? So you notice we jumped over a little batch of things when we jumped all the way from 7 to 14. We jumped over a lot of character elements that we're going to be coming back to down the road. So Article 14 is only like 2 pages long. That is the review of the ones that were introduced last month. So the next part's going to go a little quicker because I'm introducing the next batch of articles. And then we'll review them after you've had a chance to read through them, okay, at the next meeting. And we'll start with Article 22, which happens to also still be in that administrative and procedural category in your reading guide, that boring stuff, remember? Still boring stuff. Still in the boring level. Article 22, the title of that, nonconformities, that is the proper term for what has commonly been referred to in our society as the grandfather clause. I call it the grandparent clause. What that means, if you think about what you're familiar with in the traditional interpretation of a grandfather clause, you say, well, it was already there and then the rules changed, so I'm grandfathered in, right? That's kind of the logic that people perceive the grandfather clause to mean. Well, believe it or not, when it comes to development, you are looking at the clause. It's not somewhere hidden somewhere else. This is it. This is, Article 22 is the grandfather clause. A nonconformity means that when it was built, or when the lot was platted, or whatever the case is it a house, is it a store, or maybe it's a little neighborhood store that was opened back in a neighborhood, little corner store, before the zoning went into effect. They said, oh, yeah, it's a residential district. Or before the lot size said it had to be a certain amount. Or before the house was built, when they started to require that it needed to be set back a few feet from the property line, or something like that. Or the garage had to be set back 3 feet or 5 feet or something in modern times, but in the old days you put the garage all the way back in the corner of the lot. Well, that's what these nonconformities are about. And there are traditionally two categories of nonconformities. You'll see the first one appears at the bottom of page 1. It's called a dimensional nonconformity. And that's where you might refer to something as a nonconforming building. Maybe that building was built right up to the property line back in 1943. Well, 53. Probably wasn't built in 43. Built in 53. Built right up to the property line, and then in 1970 they adopted 5-foot setback. So it's been grandfathered in since the 1960s when they adopted, or 70s when they adopted that setback, right? And that's a right that we will protect throughout time. So any nonconformities that existed as bona fide nonconformities are respected by this new ordinance. And that's one of the reasons why it's important in clerk world that those old ordinances be retained as a record. So we show when it was adopted, the old one, we take a copy of the old one that says it was adopted in 1970 and it was repealed in 2021, or whatever the date is. So we know how to go back and reconstruct somebody's grandfather clause rights. You see what I mean? Now, if it was illegally done, if the law in 1970 said it had to be a 5-foot setback, and somebody decided to go out there in 2017 and build it anyway, that's not grandfathered in, even if a new ordinance takes effect. If it was illegally done, when it was done, it's still illegal. This does not let any illegal things that were illegally done off the hook. If they were bona fide nonconformities, meaning they were there first, then the rules changed, it respects that, and they can still continue. Okay? They can still continue. That building can stand there. Now that's a dimensional nonconformity. The next nonconformity is a use nonconformity. A use nonconformity is that activities. I got a gas station or a little neighborhood store back here, and that's a residential zoning district when they adopted zoning in 1970 or whatever. But back in 57, when my grandparents opened up the little store, and it's been there ever since. Well, that use is grandfathered in. It can continue. It's a non-conforming use. And there's parameters there. I highlighted in yellow how long something can discontinue before it loses that right. So let's suppose that little store closes down and somebody's been using it, my brother's using it to store stuff in. He just puts boxes in there of, stuff because he's got all these old things he wants to put in boxes and put somewhere. and it's no longer a little store. Well, the clock starts running, and that 730 is actually days, but that's really 2 years. The 1095 is a third year. If they're making a concerted effort, they're actively trying to get something to happen, then ultimately, if it doesn't, it sunsets. The grandfather clause can be lost if they discontinue or stop or cease operation or meet any of these criteria. Does that make sense? And the yellow means you might say, well, that's too long. We want to yank the rug right out from under their feet, within just a few months. Well, that's okay too. I normally use these numbers because of being economically sensitive to these folks, because a lot of times there's some distress in their economic picture as to why something might have closed. Could have been a death in the family. Could have been any number of things. If you want to shorten those time frames, by all means, there's not necessarily a criteria out there. I wouldn't go shorter than 6 months. There's one court case that was not in North Carolina, but it was back in the 80s that, and I won't get into it, but that it kind of you could draw from it that there needed to be some reasonable time frame of this sequence of events before that was lost, not just the door was locked and they closed up yesterday. Now, I want to mention the third category, which begins at the bottom of page 2. But before I go into it, I want to tell you why it's in here. Most ordinances, probably 99.999% of the zoning ordinances written in this country, deal with nonconforming uses and dimensional nonconformities. But there's one little category out there that tends to fall through the cracks. Let's suppose that instead of that little corner store, what I actually have is I have a 1957 mobile home. I mean, it looks cool too. It's got the kind of fins, and it's got a tongue, and it's got tail lights and a tag mount. There's one on Ennickville Avenue that I ride by all the time, and I see it, and I just think it's fascinating looking, because it's clearly a trailer meant to be towed. But it's a house, and it's been there forever. If you look at the use, which might say you can't expand you cannot expand a non-conforming use beyond the dimensions that it had, but then you look at what the building inspector is going to require, and they say, well, there's no way we're going to let you have this. You can't use 8 foot wide that doesn't meet the HUD standard anymore. We're not going to give you a permit. Then what that means is that between zoning and building code, that 1957 unit is trapped. It's frozen in time. And that's why it's still there, because those people can't replace it. So there's a catch-22 between the non-conforming use and the dimensional non-conforming standard when it comes to manufactured housing, because of the federal government's change in some of the codes that affected manufactured homes. And I've always felt that that was a bit harsh, because we really don't want to torture them to make them get rid of it, do we? Wouldn't we really rather, if it's there, wouldn't we really rather it maybe be a better one in better condition? Or do you want to just torture the community and make sure that that 57 model mobile home stays there for another 50 years? So I provide this out. It says, yes, you can replace an existing non-conforming manufactured home with a newer, better compliant one, even if it's a little bit bigger, because you can't buy another 8 foot wide. That can't be permitted to live in. That's where there's a collision in the laws and the codes. So beginning at page 2, there's a section where it's about manufactured homes in a park, in a manufactured home park, which those generally are installed to what's called a temporary standard, meaning they're tied down their own blocks, maybe. Okay. And then the second part at the top of page 3 that deals with individual unit on an individual lot, which might be a permanent installation or it might be a temporary installation, but it's an individual unit on an individual lot. Both of them allow for those units to be replaced, provided that they take action within, say, a year of the old unit being moved out. And that old unit could be moved out for a number of reasons. It could have burned, If it did, you know, do they just abandon it, let it sit there, or whatever? So we want them to take action. And then the last but not least is it's clear that in any situation, you can maintain and repair nonconforming properties. You're not prohibited from putting a new roof on a building that's too close to the property line. We want to make that clear to people. We're not trying to destroy them just because that was built before zoning set any kind of standard that made it nonconforming later on. So that's the grandparent clause when it comes to land development, land use. Because you've got things out there that happened throughout the last, how old is Landis, 120 years old? I mean, you've been in the electric business 102 years from what I see on this poster. So there's stuff out there. Now, a lot of the new districts that we're going to be working on when we get to Article 8, we're going to try to make sure that we don't have as many nonconformities as we might have in the past. Because a lot of towns made the mistake of adopting new development standards in old neighborhoods, and that created problems. Right out of the chute, you had people with non-conforming buildings. And so we look at that very closely. Article 23 is not going to require near as much time. It is the part that creates that planning, zoning, subdivision administrator. Goes into violations, enforcement procedures, remedies, civil penalties, all of that stuff. So if you want to read about that, there it is. That's the penalty provisions and everything in draft form for you to look at, and then we will go into the deep dive on that at your next meeting under the review. So I've introduced 22 and 23. I know 22 I gave you a little bit more explanation because of the, you know, what that really means, what the nonconformities really means, about the grandfather clause. But I wanted you to see that. Article 18 is the beginning of the what I'm going to call them, what I call in the reading guide the mandates or equivalents to mandates. If you want to play ball in the National Flood Insurance Program, if you want to be able to get flood insurance policy, you have to adopt a flood damage prevention ordinance, and this incorporates it inside the development ordinance and codifies it into it as a section. This is based on a brand new, fresh off the press model from the state that we just got in the middle of last week. They apparently had some time on their hands, and so they went in and played with it a little bit. There wasn't a lot of change to it, but there was enough. So what we've done is this version that you have here just make sure. Let me look at a couple of things real quick and make sure the right one got printed. Yeah, February 4th. Is the new 2020 model. So that's something almost nobody in the state has adopted yet, because the state did it last fall, but didn't tell anybody. Till the other day, I'm talking to the guy, and he says, "Oh, by the way, we got a new model. We need to get that out to everybody." And I said, "Well, send it to me." So we've done that. And we're moving it into a bunch of towns. Like Rutherfordton has already had their public hearing, and they're going to go ahead and substitute it before they vote to adopt in a couple of weeks on theirs. That's how important it is to a bunch of them. There are some things in it that I want to point out. One is that the state is pushing hard to raise the freeboard. That is the space between the finished floor elevation of a structure built in a floodplain and the base flood elevation in that 100-year floodplain. For the last 30, 40 years, it's been 2 feet, which is clearly proven not to be enough. Because a 100-year floodplain is actually not a 100-year floodplain, and everybody's trying to move away from that terminology. It's actually the 1% chance floodplain. Yeah, you could say that means one in 100 years you're going to have it. The problem is we typically sometimes we have 2 a year. And that 4 feet, 2 feet is not proven to be enough. The state's recommending we move to 4 feet. I'm recommending 4 feet on mapped floodplains. That is those where the analysis has been done, which are largely your major tributaries, and 3 feet on your unmapped. That's usually your little small branches that work their way up, so we don't, you got a lot less threat of a major flood up those smaller branches than you do in the larger tributaries into your creeks and rivers. And so that's what's in the draft right now. A couple other things that it does, just to point it out to you, they really are tying this back to record keeping. For the first time ever, they always had us make a note of when the flood insurance rate study maps were approved for this area, but they never made us go back and tie it all the way back to the date that the town first adopted flood regulations. And since that wasn't good enough for them, they decided to go ahead and make us tie it all the way back to when the county first adopted flood damage prevention regulations. So they're starting to fish hook these things together because FEMA is spending a lot of money dealing with flood damages. So that's what 18 is. In 19, we're going to ask you to kind of ignore what we gave you, because we're working with the town's engineer on possibly modifying some stuff. This one basically deals with some basic watershed stuff, but we're looking at modifying that a little bit, because you've got 4 different watersheds, and so we're talking about maybe going in and customizing a little bit of that. And then Article 20 is going to be removed entirely. There will not be this Article 20 unless the town engineer changes his mind. Right now, we're gonna take this out, because right now what we have is a relationship with the county where the county handles that. The way this is written is if the state was doing it in this location, then we want to make sure we got the ability to have a tie-in. The county's not as bad, and I'll tell you why it's important. If I'm a homeowner here in town and it's Friday afternoon or Saturday and there's a deluge happening, the rain's coming down like crazy, and that restaurant that Rick the scoundrel is building over on 29 is running wet red mud on me like there's no tomorrow. That little black fence is not even holding it back. It's coming over and it's making a mess out of my driveway and getting under my basement and whatever else, and I'm gonna call that guy right there. And he's gonna jump on the phone and call this guy right here. And this guy right here is going to either call his staff or he's gonna call that person. He's gonna say one of 2 things. Either we'll get right after it, we'll get somebody on it. Thank you, ma'am, for calling. We'll get a call into that contractor and get them out there to get that address right away. Or, and the reason I put this in here is if the state's doing it in your area, the answer is not our jurisdiction. That's the last thing these guys are gonna want staff telling a citizen when it is all breaking loose out there. And it's going on right now. And you're telling me there's nothing you can do about it? What this draft does is if another agency like the state administers your soil sediment erosion control, this gives you enough standing to where you can at least get that contractor's attention, where the town has standing in it. You're not just saying, well, I'm sorry, you'll have to call somebody else. Because that just doesn't play well. When there's an emergency going on with a permit that the town just issued to build a restaurant. You follow me? So that's why I put this in here. This abbreviated version is enough to deal with enforcement. But because the county's doing yours, it may not be necessary. Wes and I are talking a little bit about that. From the technical standpoint, he sees it as unnecessary. From a political standpoint, I see it as a not doing any harm to be in your ordinance rather than just being taken out. So, for your Board of Aldermen, that's just so that you kind of got a little feel for what the conversation is looking like. I like having the tool in the toolbox if it's needed. If I need to get somebody's attention, I need to know that I'm standing on solid ground when I do it. I'm not bluffing on the phone with somebody, okay? Because when I do it, I usually do it I'll say, I'm holding in my hand right now. When I get on the phone with somebody, I get it out, so I am not blowing smoke at them, I say, I'm holding in my hand right now, blah, 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 whatever it is. And it works. And so that is the introduction to 19, which was very brief, kind of skipping over it, and a little bit about 20. With that said, knowing that we're going to be coming back and going through review over the next period of time, I do want to take just a moment to point out, I don't know if this is what my reading guide looks like. I got notes all over it. Just so that you know, we just concluded the rollout of all the boring material. So now it's party time. It's time to look at the stuff that really creates the character of our community. It's those standards that create the character. And that's why we're flipping all the way back to number 2. Number 2, and the statutes, the one thing, the nice thing that the new statutes do is they actually legitimize something that a lot of us have tried to do on our own for a long time, and that is creating general standards that just apply across the board. In the past, the way the law was written, it actually kind of made it sound like all the standards needed to be defined by districts. You know, like it's in these districts and those districts. Well, a lot of this stuff really goes kind of across the board. A driveway permit. Doesn't matter what district you're in. A driveway permit is a driveway permit. A fence. I want to put up a fence. There's no setbacks that apply to fences. The only criteria is keep it on your property. Don't go, we always like to recommend to be about 6 inches off the property line, so when you dig the hole, you're not digging up someone else's property. So that's what this is all about. And there's all kinds of mess in there. Everything in there. Septic tanks and wells and murals and works of art and public view and short-term rentals. Can we all say, what's the name? What is it? Airbnb. All that stuff. Article number 2 is where you find all this stuff that's really not about new development. A lot of times it's about behavioral related things that go on in the area, or maybe tweaking things you've already got. A lot of the other character articles are you're building a new parking lot for your new restaurant. You're going to find that stuff in more detailed district standards. But in here, there's all kinds of little things, like the relationship of an outbuilding to the house. What setback does it meet versus the setback that my house meets? Or, what if I've got this giant utility building that's 4 times the size of my house in the backyard? That's where where you can deal with those kinds of things if they create any heartburn. So this is where the character comes in. You guys are going to be saying, well, I saw this one day and I really didn't like it. And I want to raise that question about how would we set a standard that would prevent that issue from happening again? Our old ordinance maybe didn't address it, so you ended up with some outcome that people just weren't happy with. And this would give you, this is the kind of section where we can talk about that. And if it's within the boundaries of the statutes, then we can put it in there. If it's out of bounds, I'll tell you. If you want to say, well, we don't want puppies in front yards. Well, that's not a zoning thing. Okay, fences in front yards, yeah. Razor wire, no. Do you want to limit fences to decorative material or not? All those are subjects that you can. So when you read this and you see it and you say, well, gosh, Rick's got this too stringent for us. If I didn't give you something to look at, it would be a lot harder for me to say, well, what is it you really want to try to accomplish? Let me go try to write something up and bring it back and forth. So I'm kind of showing you all the ingredients. I'm laying all the stuff in the ragu sauce out on the table. And then you can go in there, and when you see something you feel is just not a good fit for you, or that you want tightened up or loosened up, thrown out, turned upside down, then during that review process that we're going through, now you'll see where we're going over the next few meetings, where we're going to really get focused on the character. But that's what Article number 2 is. Now, I do want to point out, there's a piece of the puzzle in here. And, and different things might live in different places. But I want to call your attention down to, in that table of contents, down to 20.20, manufactured home parks prohibited. There's a reason to put that language in there so that it doesn't just happen. A mobile home, manufactured home park is 2 or more units on a single piece of property. So we're not wrestling with, well, now we got somebody putting stuff in their backyard. So the first thing we do is we prohibit it. Then when you read the language, it says unless. And unless is one of 2 things. Unless you're either already there, and if you're already there, then there's some provisions for how we deal with that. If we want to set a standard for them to make sure that they meet, and if they can't meet it, then go away over time or stay, all that, but you'll be able to see that. Or is it something somebody wants to do brand new? Somebody wants to come in and do a nice park, maybe to accommodate some tiny homes or park models or retirement or age targeted or RVs or any number of things that could be the opportunities. What would that look like? Oh, well, that would have to be in an overlay district. An overlay district is where you might have a residential area and somebody wants to do manufactured home park. Well, they'd have to have a rezoning to get that overlay. So that you add a few steps in there to make sure the public's all aware, and that the governing board can say no if they want to, but the tools are in the toolbox. You've got a pathway towards that where people don't just look up one day and go, oh my gosh, I had no idea. You know, we've got this pathway. We are required by the statutes to provide for manufactured housing in our jurisdiction. We can't just take a position, we don't like it, sorry, can't have it, not gonna do it. That's not an option for us. We have to have some kind of pathway that is a form of housing that is protected under fair housing and statutes of the state of North Carolina. So that's why I do it this way. Prohibit the parks, set a standard, create an overlay district. If you want to do one on an individual lot that's in a normal subdivision, you'd have to have that same overlay district, which requires a rezoning. Still going to be residential, but do we or do we not have the option for manufactured housing? Modular is not the subject. Modular is the same as a regular house. They just build more of it in the factory. Still can't have a chassis. That's the big difference. A lot of manufacturers try to make them where they pass both. Well, the primary difference is a chassis. My first court case was on this subject in 1986 or 7. Okay. It was in South Carolina, so I can't remember if it was right in the beginning of 87 or not. I moved up here in May of 87. As an expert on that subject, so there's a lot to it. Manufactured housing is one of the more complicated arenas of housing. Nonconformity-wise, new, because there's different methods of installation, there's different methods of taxation. If it's on temporary installation, i.e. blocks and tie-downs, even with skirting, it's considered personal property. And it's taxed like your boat trailer. Okay? Which means it depreciates down to next to nothing, so they're paying $12 a year in no time at all and getting full services like garbage collection or whatever else. Okay? If it's on permanent foundation, permanent installation, et cetera, it becomes part of the real property and is subject to real property tax application. So they're paying for their way. They're paying their fair share of garbage collection or whatever else. So there's all kinds of nuances to the whole manufactured housing arena. And then you throw in all these new modern things like tiny homes and all these little trendy things, and there you have an even more complicated mix. All of that's addressed in this sequence that will have you moving around in the ordinance a little bit, from prohibiting the parks to, oh, here's the nonconformity provision. Oh, here's an overlay district. Oh, here's a special use or provision for new parks. Oh, here's a installation standard for replacement homes. We got the basis covered, so we'll work with your staff to make sure they know how to navigate that, because they end up finding their way all over the place in the ordinance, okay? So that's what Article 2 is really about, but I wanted to point out the manufactured housing, because I advocate that you have a fair and equitable process that doesn't create problems for the community in the future, because I've seen it be that pendulum swing all over the place. And the way I've got it set up in the toolbox right now, you should be able to manage that based on careful, logical decision-making, okay? And satisfy the statutes along the way. So that's Article 2, the first of the character articles. The next one and the last one that we're going to talk about tonight is one of the easiest ones and one of the also more controversial ones. And I'm just going to introduce it tonight. And oh no, I don't see it. It's not printed.
And I was going to interject as well. I didn't have a.
Yeah,
I didn't
15
have
did not get
15.
printed. Well, let me tell you what it is. It's only 2 pages long or 3 pages long, so I'm just going to tell you what it is. It's that little thing that deals with those temporary things, meaning, and the list is enormous. Yard sale, pods. You know what a pod is? Those things that they drop in your driveway because you're doing some remodeling and you're going to have that sitting in the driveway for 4 months, and or some water damage or something like that. You got to have some basic guidelines for that. And you're going to see all kinds of stuff in there. Food trucks. Tailgate markets. In other words, I'm selling watermelons. I parked over here at the gas station. I'm selling watermelons. And somebody called town hall because they didn't want me doing that. What are the provisions? How does that work? Yard sales. Seasonal sales. Church selling Christmas trees. Believe it or not, you really need to have your arms around all this. Other itinerant merchants. I got a tractor trailer, and on Saturdays I pull up across the street from the local furniture store and I sell recliners. and the folks that own that furniture store call town hall on Monday, and they're just livid. Because here I am, I'm not paying taxes or anything, and I'm in here lowballing, undercutting their prices. We have to deal with that. We have to speak to it. So when we get the call, it's not that we're out there necessarily looking for it, but when the phone rings at town hall, we've got the answer. So that's what 15 is. I apologize for that not getting printed, but that was the last one to introduce of the articles. There is one more item to introduce on the agenda that's not one of the articles, though, and I want to mention that to you. And that is, we talked, before you convened the meeting, I mentioned that if you saw that on your tables, it belonged in tab 27, and I want to speak to it now. That's those rules of procedure for the planning board, and the planning board rules of procedure are about 4 pages long. They do get onto a 5th page with some signatures and all that. And then there's rules of procedure for the Board of Adjustment, which are about 8 pages long or so. Is it 8 or 9 now? Signatures take it to 9. You are now required to have those, and you're required to publish those. And so while the Board of Aldermen holds the prerogative to set those rules of procedures under which the boards that they appoint will operate, I like to have the boards review those and make a recommendation, because they're the ones that have to think through, how am I going to conduct these meetings? This is where we can actually set up how you want your agenda structured, any of that sort of thing, okay? So take time to read through that and what have you, and then that material under item 7 on your agenda, that's 22, 23, 18, possibly 19, maybe not, but 20, 2, and then 15. And I don't know what to do about getting 15 out to you. I'm going to ask Mr. Barefoot if that's possible to maybe follow up with staff and see if there's a way for them to get their copies of
If you can get it to me, I can get it to them. What you're referring to in the draft rules, where was that information?
The rules of procedure?
Yeah, the draft rules procedure.
Did they put it
Was it
in-
not in your packet?
Did they put it in the back of your binder? Didn't Shelley update yours today?
Tab
She did.
27?
At 27, I got you. Yes. Yes, sir.
Yeah, the
Okay.
table of
That's-
contents points to
I
that.
forgot you said it was
Right.
27.
All right.
So I have that.
I was about to make a wisecrack. I was saying, they didn't want you to know about it. Can't have a little bit of fun with this, you know? So anyway, that concludes, Mr. Chairman, members of the board, the introduction of the next batch of articles for your reading pleasure. At your next meeting, we'll review those, and then we'll have a new batch of a lot more of the character-based type articles for your review.
Good. Okay, well, I guess if that's all you have, I'm gonna start wrapping
Do
things
you
up.
need more?
Please. I dedicated my whole afternoon for you, so
Now,
you're
this
fine.
is, that's all I have for you tonight. I do
Okay.
have we could talk about the schedule.
Yes.
If you would like, Mr. Chairman, I don't know if you were gonna bring that up, if you, I'll be happy to respond to it, but that was all that I had for that agenda item without you recognizing me for more.
I would actually like to have nothing that would go so far as having a formal vote on what we're gonna do on that matter, but I'd like to at least bring it up to the board's attention, so it's something they can be considering.
Keep in mind that the statutes paint us into a hard corner. We are required to have our work completed, and the aldermen have their work completed no later on the ordinance work. Plan's a little different, but the plan needs to be in front of the ordinance, so we're doing them at the same time. But they need to be done so that the new stuff is effective not later than July the 1st, which means they need to be able to vote in June. For them to vote in June, they have to have had a public legislative hearing on the plan and the ordinance, separate hearings on the plan and the ordinance, and the luxury to be able to take those comments from the public and allow your staff and team, that I'm part of that team, to make any changes, modifications, or what have you that result from the hearing that you hold. So we're trying to leave you some room for that at the Board of Aldermen level. In order to do that, we have to have ample time to meet the notification requirements required by the statute, which means that for us to have a hearing and vote in June, we have to have absolutely, with no time to spare, we need to be rolling in May towards that, because we have to meet a 10 to 25 day notification rule. We've got mail out stuff to do to non-local mailing addresses, people with tax bills that receive them. Maybe they live in Virginia or Florida, but they own property here in town. We will send them the same thing that's in the newspaper, so they see the map, they see the notice, they get the information. So with that sort of backing into it, that means that our recommendation at the planning board, your recommendation at the planning board, really needs to be formalized not later than maybe early May. Since you meet on that second Tuesday, May, your regular meeting date in May, which is kind of the absolute end of the window, is the 11th of May. That's putting the Board of Aldermen in a little bit of a tight squeeze. They're only going to have this material for a couple of weeks before they're holding a hearing, and then they're going to be voting on it shortly thereafter. That time's going to fly by. The great thing about it is you've had an alderman attending that kind of has a finger on the pulse of what's going on at the planning board level. Some towns stay completely out, and so I have to kind of start over with them, introduce everything and all that. So my hat is off to the town for having an alderman present, liaison from the alderman to the planning board. With that said, my recommendation to you is that you target trying to make your recommendation in April. Then you've got the fallback to the May 11th meeting as your fallback. I don't want to target the last possible date as the target date and then us have a glitch. A glitch might be, for example, not having a quorum at any one of the meetings that you have between now and then. Because if you have no quorum, and that's why you have one member by phone and 3 here, if you have no quorum, I cannot proceed. That night, I will not present, I will not go forward, because that might jeopardize the legitimacy of the process of crafting the ordinance and making the recommendation, which would overturn it all if it were challenged. Could potentially overturn it all if challenged.
However, though, if we follow suit with if the planning board follows suits with what was done in January this week, for this month, as well as in March and April with presuming a quorum, you're proposing April could work with not much modifications.
Right. I would suggest.
And that would allow a few more weeks or at least a month's more time versus rolling into May for Board of Aldermen and proper notice, correct?
Absolutely. If in February and March you considered, if you feel that you have the need, because we've got the material, I'm just trying to prevent from turning the fire hose out on you, and just washing you out with material. If you would consider doubling up, maybe have a situation where you would continue one of your meetings rather than adjourn until the March date, whether you would continue this meeting until maybe a date in a couple of weeks and come back together so we can kind of stay ahead of that curve and get it off the plate. If we did that in February and March, then we could kind of get ahead of that curve so that by April you will have had plenty of time. The last thing I want to do is for you to feel that you haven't had time on this material. And so that would be an option that you can consider. The way to do that would be not to adjourn a meeting, but to continue it to a later date. Then after you finish that night, you could adjourn until your next regular meeting in March. And then we do the
So
same
it
thing.
adds, it adds an additional night.
That's right. It wouldn't be setting a full-blown meeting. It would be a continuation of the same meeting. So if we came back, just as an example, to make this as clear as I can, if you were to take a motion to recess until, say, if we go out 2 weeks from now, that's the 23rd, which I have a conflict that night. So maybe if we could do it the next night or 2 nights later, like the 24th or 25th, that's a Wednesday or a Thursday. If you recessed until that time, 5:30 or whatever time you select on some date, and you state that in the motion, you're doing it in public meeting, so you don't have to do any special notices or anything like that. It's not a separate meeting, it's just the second half of the February 9th meeting. And then at the end of that night, you could adjourn, and then your next regular meeting would be March 9th. And if you wanted to continue it, you could do it again, and then you would have really caught up and gotten ahead, and you've given yourself more breathing room and more hands-on. That's asking a lot of you as volunteers.
So what would you, what would you be expecting to accomplish at the meeting in 2 weeks?
Having the review of the material we just introduced tonight, instead of having a whole month to look through that little batch that we just introduced tonight, to try to get back in a couple of weeks and have any comments back or questions back, I'm not expecting
An introduction of the new articles.
And then we would introduce another batch of new articles 2 weeks from now. And kind of keep rolling so that by the time we get into March, you've got everything in your lap, and now we're looking at the maps, we're looking at things like that, so that we're refining everything, and then in April, at your regular meeting in April, maybe you would be prepared to say, okay, now I'm prepared to make the recommendation for the Board of Aldermen. That's kind of where we are, and the state's got us where we are, kind of up against the wall. If you don't do those extra meetings, I'll do my best to introduce the material, and maybe you just, there's a lot more faith in it, but I want to make sure you've got everything you need as a planning board from me.
But I understand and I appreciate it. I think the only question or concern I've got in the back of my mind is ensuring that we've got a quorum when we're adding an additional night, because a lot of the board members do work. And I think it's going to be a matter of everybody's schedule and making sure they're going to be able to be attending on those additional times that we're discussing here. And I'm not sure even tonight we can even answer that question tonight.
You could probably send out an email with the two dates and see which one works best for
At
you.
which point in time you could advertise for a special meeting?
We'd have to advertise it. I mean, you could go ahead and take a stab at a meeting and recess this one, and if, once you polled everybody, there's complications, then we'd have to advertise it. So we could advertise to withdraw the continuation of this meeting on the 24th, if that's where you want to set it.
What
until-
would be the date recommendations we're talking about?
I have a conflict on the fourth Tuesday, and I apologize for that.
He's not available the 23rd, but said the 24th or 25th works for him.
Which would be Wednesday or Thursday of that week.
Right.
That gives you a couple of weeks. Do y'all feel okay, looking at that material that was introduced
I'm gonna
tonight?
look to you guys for feedback. Well,
Yeah, I'm good with either date.
So am I.
Go ahead and go to 24th and let's look at that date.
24th works for you?
I like it better than the 25th. That's my 48th wedding anniversary.
So if you're going to entertain a motion, Mr. Chairman, to continue until that night, make sure that in the motion, for you board members in the motion, that you state that you would move to continue until, and state the date, and state the time, and state the location, here in council chambers, or however you want to phrase it, so that it's clear in the motion for the clerk's record as to when you will be reconvening. So this will be like a recess. You're continuing, you're going to recess and continue the meeting until that night, at that time, for the purpose of continuing with this project.
Okay, so just to formally say what you're saying, you're saying that we should not close this meeting, we're actually going to recess this meeting, and that's the motion that we're now asking for.
Correct.
Okay, so I'm looking for a
So,
motion.
so I make a motion to recess until, to the February 24th meeting at 5:30.
Okay,
All right, I second it.
Here in town, here in
Yes, sir,
town.
at City Hall, yes. sir.
yeah, okay. So we'll vote, all in favor? Okay. So that puts us here. That's why I didn't want to, when you asked me if I was done a while ago, that's why I didn't want to answer that question.
I just wanted to say one thing, and I think Rick did a wonderful job. It brought back a lot of memories for me. The first half of my career, I was a planner, city planner, and then a county planner. And I have been through numerous Board of Adjustment hearings and, wrote a zoning ordinance. My point is, if you have questions and you can't get to Rick, pop me an email or give me a call, and there's a fair chance I might be able to help you.
Good.
At least to help you understand it.
Sure.
His expertise is far beyond mine, but he's also, in this case, he has done this before, and, moving it over to 160D is a skill that I don't have and didn't want to have to do this, and we're thrilled to have Rick here.
Okay, good. Well, thank you. Thank you for the offer. Okay, then I think that officially recesses this meeting until the 24th. Thank you very much.
Thank you.
Thank you.
Thank you.
We actually had a hearing on the variance, which I think it was 4 or 6 inches on the roof.
Bill, we missed you last time. Welcome aboard.
Thank you.